In recent years, the commercial assignment of debts has become commonplace, often automated, frequently undocumented, and almost universally misunderstood. Behind this industrial practice lies a fundamental question of law. What is required to transfer legal ownership of a debt, and who, if anyone, acquires the lawful right to enforce it? Today's session will examine this question through the lens of black-letter statutory authority, specifically Section 136 of the Law of Property Act 1925. This is not a policy debate nor an exercise in interpretation stretched to accommodate industry custom. This is a walk through the law as written, as intended, and as upheld in the courts. For those studying the intersection of statutory and equitable rights, this session serves as a structural analysis, not advice, not opinion, but doctrine. Our focus is clarity, our goal is understanding, and our subject, the transfer of legal choses in action, lies at the very core of enforceable obligations in English law. We begin now with the statutory text itself, Section 136 of the Law of Property Act 1925, a statutory provision that governs the legal assignment of debts and other choses in action. While frequently referenced in commercial practice, its legal meaning is often misunderstood, or worse, misrepresented. Section 136 of the Law of Property Act 1925 provides that a legal assignment of a debt or other chose in action must be, first, absolute, second, in writing, third, executed under the hand of the assigner, and fourth, accompanied by express written notice to the debtor. These are cumulative and mandatory statutory conditions. Absent compliance with each, legal title does not pass, and the assignee cannot sue in its own name. In plain English, this means a debt cannot lawfully be sold or enforced by someone else unless the original creditor has properly signed it over in writing and the debtor has been formally told. If a company is merely listed on a spreadsheet database or bulk data transfer without a signed assignment from the original creditor, then ownership of the debt has not legally changed hands. In that situation, the buyer may have information about the debt, but it does not have the legal right to enforce it in court. The phrase "under the hand of the assigner" has a precise and settled legal meaning. It requires execution by the party who owns the property at the moment of transfer. That is, a written instrument signed by the assigner, evidencing an intentional transfer of legal title. This requirement exists because property cannot pass by implication, inference, or administrative convenience. Legal ownership moves only through formal acts recognized by law. A debtor's obligation may be enforced only by the party holding legal title, and legal title passes only by strict compliance with Section 136 of the Law of Property Act 1925. This principle has been consistently affirmed by the courts for over a century. In plain English, a debt cannot be sold simply by updating a spreadsheet, notifying a regulator, or asserting that an assignment has taken place. The original owner must sign a document transferring the debt, and the debtor must be told. If that does not happen, the buyer does not own the debt in law, even if money changed hands. Van Lynn Developments v. Peleus Construction, 1969. In Van Lynn Developments v. Peleus Construction from 1969, the Court of Appeal made the legal position absolutely clear. The debtor, the person who owes the debt, has the right to see proof that the debt has actually been assigned. Just saying a debt has been assigned isn't enough, and simply sending a notice doesn't create legal ownership. Plain English. You can't just tell someone a debt has been transferred and expect them to accept it. You have to show proper legal proof that ownership has changed hands. The court emphasized that it must be satisfied that legal title, the official legal ownership, has genuinely passed. This case confirms a critical principle. Title must already exist before notice can have any legal effect. Van Lynn clearly rejects the idea that a debtor must just take the new owner's word for it. Plain English. If you say you now own a debt, the law says, prove it, don't just assert it. Binding authority, historical and modern. The courts have never wavered on this point. For well over a century, the higher courts have consistently held that legal title to a debt does not pass unless the assignment itself complies with the law governing property transfers. In William Brandt Sons and Company versus Dunlop Rubber in 1905, the House of Lords made it clear that commercial expectation or business convenience cannot substitute for a valid assignment. Legal title does not pass unless the assignment is properly effected in law. That principle was reinforced in W. F. Harrison and Company Limited v. Burke in 1956, where the court confirmed that notice to the debtor by itself does not create ownership. Notice is only effective if legal title already exists. And in Van Lynn Developments v. Pellias Construction in 1969, the Court of Appeal settled the matter beyond doubt. A notice of assignment cannot cure defects in title. The assignment must be valid first. Legal ownership must exist before notice has any legal effect. These are not obscure or technical cases. They are foundational authorities. They sit at the core of English property and assignment law. Plain English, what this means is simple. A debt cannot be enforced by someone who does not legally own it. Sending a letter, issuing a notice, or asserting that a debt has been assigned does not make it true. Ownership has to exist first, and it has to be proven. If the original creditor did not properly sign away the debt in accordance with the law, then no amount of paperwork, notices, or claims can turn that into legal ownership later. In law, title comes first, notice comes second, and without title, there is no right to enforce. Frischmann v. Vaxil Holdings, 2023. In Frischmann v. Vaxil Holdings 2023, the High Court did not create new law. It reaffirmed what has always been the position in English property law. The court was explicit that a notice of assignment is not evidence of legal assignment. Legal title to a chosen action does not pass unless the assignment itself is validly executed in accordance with statute. Crucially, the court confirmed that legal title cannot be inferred, assumed, or reconstructed after the event. If the assignee cannot produce the executed instrument of assignment, the document made under the hand of the assigner, then legal title has not passed. This judgment does not innovate. It restates settled black-letter law derived from Section 136 of the Law of Property Act 1925 and the long line of authorities preceding it. Because this was a High Court decision, it is binding on lower courts and decisive on the point. It closes the door on arguments based on commercial convenience, internal records, or bulk data transfers. Plain English. If a company says it owns a debt, it must be able to prove it by showing the signed legal document that transferred ownership to it. A letter, a database entry, or a spreadsheet is not enough. If they cannot show the executed assignment, then in law, they do not own the debt, and they have no right to enforce it. Technocrats International v. Frederick, 2004. In Technocrats International v. Frederick 2004, the High Court addressed a point that has become increasingly important in modern commercial litigation: the distinction between legal ownership and administrative record keeping. The court reaffirmed that a legal assignment of a chosen action requires strict compliance with Section 136 of the Law of Property Act 1925, including actual execution by the assigner. Assertions of transfer, internal accounting entries, or data schedules do not of themselves effect a transfer of legal title. Crucially, the court made clear that internal systems are evidentially irrelevant if they are not supported by a properly executed written instrument. Ownership is determined by property law, not by database entries, commercial process, or downstream assumptions. This decision reinforces a long-standing principle. When legal title is disputed, the court looks to the executed document itself, not to what parties say has happened behind the scenes. Plain English. Put simply, this case confirms that you cannot transfer ownership of a debt by spreadsheet, software, or internal paperwork. If a company says it owns a debt, it must be able to produce the actual signed document that transferred it. Computer records, data files, and internal notes may show what a business intended, but they do not prove what the law requires. In law, ownership only changes hands when the proper legal document is executed. If that document does not exist, legal ownership does not exist, no matter what the system says. Why Section 136 cannot be reinterpreted. Section 136 of the Law of Property Act 1925 is not a flexible or discretionary provision. It is a rule of property law and its operation is precise. The statute requires execution by the assigner because legal title to property cannot pass by assumption, internal process, or regulatory convenience. Whether the property is land or a chosen action such as a debt, ownership transfers only through compliance with the conditions Parliament has prescribed. Importantly, while an assignment need not always take the form of a deed, it must nevertheless be executed, that is, signed under the hand of the assigner. This requirement is not optional, and it cannot be diluted by commercial practice or industry custom. Courts, not regulators, determine when legal title passes. Regulatory guidance may inform conduct, but it cannot override statute, nor can it displace binding judicial authority. Where Section 136 is not satisfied, the courts have consistently held that legal title does not pass. Any argument that title may pass without execution contradicts both the statute itself and over a century of case law, including decisions such as William Brandt's Sons v. Dunlop Rubber, W.F. Harrison v. Burke, Van Lynn Developments v. Pelias Construction, Technocrats International v. Frederick, and most recently Frischmann v. Vaxial Holdings. The position is settled. Section 136 does not bend, it governs. In plain English, this means a debt cannot legally be sold or transferred unless the original owner actually signs it away. It is not enough for a company to say, we bought it, or to send a notice, or to point to a spreadsheet or database entry. If the original creditor did not properly sign the assignment, then ownership never moved. And if ownership never moved, the new party has no legal right to enforce the debt. No regulator can change that. No industry practice can override it. Only the law decides who owns property, and Section 136 sets the rules. Consequences of non-compliance. Where Section 136 has not been complied with, the legal consequences are straightforward and severe. First, legal title remains with the original creditor. If the assignment has not been validly executed under the hand of the assigner, ownership simply does not move, regardless of what internal records, databases, or notices may suggest. Second, the purported assignee has no standing to enforce. Without legal title, there is no right to sue, no right to demand payment, and no lawful basis to invoke court processes. Any enforcement attempt made in those circumstances is defective at inception. Third, this is not a technical or procedural irregularity. It is a failure of legal title itself. And where title fails, every downstream act that depends upon it, including enforcement activity and data processing, is rendered legally unsound. The courts have repeatedly treated such failures as fundamental, not curable by notice, repetition, or regulatory convenience. In plain English, if the debt was never properly signed over, it still belongs to the original lender. That means the debt purchaser doesn't legally own it, can't take you to court, and has no authority to enforce it. It's not a paperwork issue, it's an ownership failure. And if you don't own something in law, you don't get to enforce it or use someone's data as if you do. Legal requirements. Recap. This slide brings the law together. Under Section 136 of the Law of Property Act 1925 sets out the conditions by which legal title to a chosen action, including a debt, may pass from one party to another. Those conditions are not flexible, and they are not matters of administrative preference. Legal title passes only by a written instrument executed under the hand of the assigner and accompanied by express notice to the debtor. That proposition has been affirmed repeatedly by the House of Lords in William Brandt's Sons, by the Court of Appeal in Van Lynn, and most recently by the High Court in Frischmann. Across more than a century of authority, the courts have been consistent. No assertion, no spreadsheet entry, no internal system record, and no regulatory gloss can substitute for execution. Where execution is absent, legal title does not move, and without legal title, enforcement cannot lawfully follow. In plain English, to put this simply, if a company wants to enforce a debt in its own name, it must actually own it in law. Ownership does not pass because a database says so. It does not pass because a notice was sent, and it does not pass because a regulator assumes it has. Unless the original creditor signed a proper written transfer, the debt never legally changed hands. And if you don't legally own a debt, you don't get to act as if you do. Please like, share, subscribe, and click the bell for announcements from www.checkmatethematrix.com.